Well, with me is a very special guest, Joel Page, who's an assistant federal public defender for the Northern District of Texas. He's chief of the appellate section. And most importantly, for our purposes, he was lead counsel in Davis versus United States, which is a winning U.S. Supreme Court case decided on March 23rd, 2020. Joel, thank you for being here.
Of course.
Joel, tell us a little bit about Davis and kind of the work that led up to prevailing in that case.
Davis was a summary reversal, and it was a unanimous Supreme Court decision decided without oral argument or merits briefing. So they thought it was pretty clear that factual error is not categorically immune from reversal in the absence of an objection. There is a doctrine in federal criminal practice called the plain error doctrine, which says that if you don't object to an error in the court below, you have to show not only that there was error, but that it was clear or obvious error, that there is a reasonable probability that it affected the result, and that it affected the fairness of the proceeding, and such that it merits a discretion, the exercise of discretion to correct. And since it's about 1991, the Fifth Circuit had applied a rule that factual error that is factual in nature can never be plain, and that was a case called United States versus Rodriguez. And I was not really clear where that rule came from. It was tracing that back. It appears to have its roots in civil cases, and then found its way into federal criminal law by way of jumping through habeas, the habeas stepping stone, just sort of both criminal and civil. I first came into contact with that rule in 2008 or so, 2007, 2008, in a case called Amaya, where an error was, they declined to reverse an error precisely for that reason, began filing cert on that case, on that issue, because wasn't the rule in every other circuit.
What you mean by that is the Fifth Circuit was the only circuit that had this distinction between reviewing on plain error questions of fact versus questions of law.
Well, they weren't the only one that distinguished them. There were other circuits that said factual error may be more rarely reversed. For instance, it may be difficult to meet all four prongs in factual in those cases, but the categorical rule was something that there was clearly a circuit split about.
Well, I wanted to ask let me ask you this. One of adding another layer of difficulty to this, in the cases that I've read, particularly in your case, for example, and in another case I handled, the way they characterize fact issues are not things that we ordinarily or always think of as purely fact issues. A lot of times they're mixed questions of law and fact. And sometimes intuition would say they're even questions of law. In your case, it was a relevant conduct determination. How frustrating was that throughout the process?
I mean, it's immensely frustrating. I mean, it's just was a real easy escape hatch, I think, for a busy court to just say, oh, this is factual in nature. And, even cases where the facts are undisputed and we're just arguing about how it's appropriately characterized, what legal standard appropriately characterizes undisputed facts, they would call those sometimes fact, or just have these little categorical enclaves of anything related to relevant conduct is a factual issue. And that's really how Davis was resolved against us, or anything that that if it were preserved would be reviewed for clear error. And so, they would use that rule for all kinds of errors that were fact and arguably probably legal error in some cases, because the historical facts were undisputed.
One of the other difficulties, I mean, courts have been telling us for some time, including the Fifth Circuit, including the United States Supreme Court, that this rule is an outlier rule. Unfortunately, it's in place unless the court were to rehear it en banc, which is very, very rare. So everyone seemed to be, a lot of people seem to be frustrated with this rule, not only on the defense side, but also on the bench. But the problem is you almost needed that perfect case before they'd be willing to take it up. You know, the case where you would have won it on plain error if only it could have been reviewed that way. Talk about the Fifth Circuit case in the Supreme Court case that where we saw this frustration, yet the courts in both instances decided not to take up the issue.
Yeah, I mean, I think they had that case twice. They had two real screaming injustices that were affirmed before they took mine, that were affirmed in spite of really pretty clear error. The first time this really got anyone's attention was Judge Prado, now Ambassador Prado, who wrote a concurrence saying that I think that we have to affirm this based on this rule, but I think we should revisit this rule in a case where the defendant was in the back of a cruiser, a police cruiser, with a co-defendant, and was solicited to, commit an act of obstruction, escape, destroy evidence, something. I can't remember exactly what the act was, but the co-defendant asked him to do that, and on the video, he declined. He didn't do what was asked of him by the co-defendant, but he still got the obstruction enhancement. There was no objection, but that was held to be whether he actually did what he was asked to do by the co-defendant, performed an obstructive act. That was a factual issue, and so Prado said, "This is our rule, and that's what we have to do." But look at the terrible result that it's creating here. And there was an exchange between him and Judge Jones, I think maybe then Chief Judge Jones, about the wisdom of this rule and where it came from. And that, I think, was the first time that it really kind of elevated. People started getting this in their crosshairs as a rule that might be worth revisiting. And then in 2013, there's a case called Carlton, which if you can imagine, I think was even worse. That was another case that came out of the Fifth Circuit. A prosecutor told a judge that he had heard testimony during the trial of the defendant that he had received drugs in prison. And in fact, the prosecutor misremembered, and had made a false statement that testimony had never been elicited in the trial. And I guess, the defense attorney, we would imagine, is hearing that and thinking, "Oh, I don't remember that," but I guess the prosecutor wouldn't say that if he didn't remember, and nobody objected to that, and the defendant was sentenced as though that testimony existed. And then on appeal, the government conceded that testimony didn't exist, and that factual finding based on the testimony was plainly erroneous. But
Joel, we cut out for a second. You were saying the government conceded on appeal.
Well, the government, I don't know if they conceded the whole case. They conceded that no such testimony had ever been elicited. But the Fifth Circuit held that it was immune from any review at all, because the issue of whether that testimony had been elicited and whether the defendant received drugs in prison was factual in nature.
And did that testimony affect the outcome in any way in that case?
Well, it was a sentencing issue, so yes.
So it came in, and
it was used.
Looks very damaging.
Right. I think it supported an enhancement too. I don't remember particularly, but and so Sotomayor noticed that and said, "Look, there's no basis, there's no textual justification for this rule, this prohibition on finding factual error ever plain, and look at the result that is occurring here." And by Justice Sotomayor's count, no other circuit applied that rule. I'm not sure if I had compiled the law at the same time, I would have said it was 12 to 1, but 11 to 1, but it was certainly not, it was certainly an outlier position. And so, you know, she really, I think, kind of filed a shot across the bow and said, you know, either decide whether you really want to defend this rule, reconsider it. But by the time that my cases weren't going up there, you know, the government was still able to cite, compile 100 cases where they were still applying this rule, applying it with regularity and consistency. And in Davis and in another case, Lindsay, which was close to the same time, when we were seeking en banc reconsideration or panel rehearing, the results that were coming from those were panels saying, well, first of all, they were declining to rehear the case en banc and saying, look, we were consistently adhering to this rule. So they had their chance. They were given a chance, and the Supreme Court didn't have any more reason to be patient about it.
Yeah. One of the things about the Carlton case is it's a mixed message. So, you know, you have at least one justice that's really tuned into this problem. And at the same time, they also expressed a view that this was not the right case to take up because it wasn't so slam dunk. When you and I look at the case and we think, how does it get any better than this? What is it that you think attracted them to Davis that they didn't see in the earlier cases?
I mean, well, I don't think that Sotomayor and Justice Sotomayor and Carlton really said this wouldn't be plain. I think that she said, we're going to give the Fifth Circuit another chance to fix this because they don't adhere to this rule all the time. They don't always, and that was a point that Judge Prado had made in the concurrence a few years earlier, but and how could they? I mean, if it's the definition between the line between factual and legal error is so murky anyway that it's not going to be hard for either side, depending on their purposes, to find cases where factual error or arguably factual error, allegedly factual error has been reviewed under plain error. So what she really did was say, I think that the Fifth Circuit law is inconsistent on this and clean it up. And so I think the cert granted Davis was impatience plus taking a panel of the Fifth Circuit at its word that they were never going to change.
Well, yeah, by that point, you had 7 or so years of the Fifth Circuit doubling down on their own rule, and the Solicitor General could no longer argue, hey, the Fifth Circuit might change that rule en banc or otherwise. Right.
And then something you see a lot of, I think, is different incentives in the courts of appeals at the Supreme Court. In the Court of Appeals, the incentive is to say that you've always applied this rule, and the Solicitor General has the incentive to say maybe it might change.
Yeah. Was there any foreknowledge or forewarning that this was going to happen, or it just came out one day?
Well, not really. I mean, there were some relists. It was relisted several times. One signal that we were that it was a plausible cert grant is we reached out to our friends at the Northwestern Supreme Court Litigation Clinic, and they are partners at Sidley Austin, Tobias Loss Eaton, and Jeff Green, and associates there, and that's a really great team, and really a joy to work with in cases like that. But we reached out to them, and they're not going to get involved in every case if they don't think it's worth their time, and or if they don't think it has a realistic chance of getting certiorari. They're not going to waste their students' time on matters like that. But they agreed to help us write the reply in Charles Earl Davis and a cert petition in a companion case, Dominic Lindsay. And so that was a sign that we were onto something. We had heavy hitters and very talented partners that were working with us on that. So that was a hint. And then the other hint was just that it had been relisted several times.
Yeah. So if I had asked you 3 years ago, what case is going to get reversed first? Call it Lopez, call it Carlton, whatever rule you want to call it, Rodriguez, or Almendarez-Torres. Which one would you have predicted comes first?
3 years ago, I would have said Lopez because we had the Sotomayor's shot across the bow.
Okay.
Yeah. 10 years ago, I might say Almendarez-Torres.
Yeah. Well, thank you so much for talking about this case. I've said I think it's a very important case just because in the practical day-to-day operations of a federal criminal appellate lawyer, you come across this because you see things that seem legal that are being construed as factual. Now you've got to add that whole other layer into your brief about problems here. I guess it could all be solved with well-preserved objections, but it's easy to miss things sometimes, and we need to keep fighting when we can, and it's hard when they take that away from you entirely.
Right. Absolutely.
So, any final thoughts?
No, I mean, it's one of two really good Davis cases that came down. Lately.
Hey,
yeah.
Hey, if the defendant's named Davis, you know who to call.
That's right.
Northern District of Texas. So thanks so much, Joel.
All right. Take care.
All right. Bye.
Bye.